talking to you about why many living trusts fail. I'm also going to talk to you about ways that you can make sure yours works when it's needed. So another title for this speech could be How to Protect Your Family and Assets Without Having to Give Up Control. Because one of the things I'm going to talk to you about today, and this is in common with all estate planning, is the sooner you plan, the more control you can maintain. If you wait until you don't have your ability to make decisions, then you're going to lose your ability to control what happens. So what you're going to discover today is ways to promote family harmony, how to leave a legacy, so how to leave your assets behind in a way that they don't ruin people, how to protect yourself if you ever need care. Because if you think about it, today we're going to talk about if you pass away, what happens to your assets. But another very important question is, if you ever need care, who do you trust to do that? And how to obtain peace of mind that you've put together the best possible plan. What you're going to discover is ways to promote family harmony. Now, if you have a dysfunctional family and they don't get along very well, I don't have a magic wand, so I can't make it where they get along if they don't already get along, but I'm going to do my best to show you ways that you can make sure that you don't heighten the conflict between them. How to leave a legacy, so how to leave your assets behind in a way that they don't ruin people. Most inheritances are treated exactly like lottery winnings, which means they're blown within a year. And so we're going to talk about some ways to prevent that. How to protect yourself if you ever need care, and how to obtain peace of mind you've done the best job possible putting together your plan. This is for you if you're worried about your family getting along after you're gone, if you're worried who's going to take care of you if you ever need care, and if you're sick and tired of worrying about your family in general. And if you're confused by conflicting advice. So nowadays we can go on the internet and we can get advice on absolutely everything. But how do we know we're getting good advice? How do we know that it's going to work for our family in the event that it's needed? Imagine having the peace of mind knowing your family is going to get along after you're gone, or at least you haven't made matters worse than they currently are. Knowing you're going to be taken care of if it's needed, and having a plan customized to your unique family situation. Every family is different, and we've got to make sure that the plan works for your actual family. Now, one of the things that I try to mention in every speech that I give is most families are dysfunctional. Some of you're fortunate enough that we have to get into cousins or second cousins before we find that dysfunction. For some of us, it's a little closer to home. But the reason why I mention that is when you work with an attorney to put together a plan, you need to trust that attorney to talk about your real family, because the plan needs to be customized to what's actually going on with your family. So a little bit about our firm. We've helped over 6,000 families protect the assets they leave behind from divorce, creditors, and lawsuits. We've also helped over 300 families implement the plans that we've designed, and over 1,200 families implement the plans that other attorneys have designed. And the reason why that's significant to you is because estate planning is kind of depressing. So you're going to want to put together a plan, put it on the shelf, and forget about it. But what's important to you is it protects you if it's needed, and it protects your family if it's needed. One of the things that's unique about our firm is we do both estate planning and elder law. Estate planning is what we're going to be talking about today. It's the who gets your stuff when you die. Elder law is planning to protect assets in case you need to go to the nursing home, or planning to protect a relative that has a disability. And we have another video on that, and if you're interested in learning more about that, you can find that video on our website. We also belong to a lot of professional organizations. So we not only learn from the 5 attorneys in our office as far as what needs to happen for your documents, but we can also learn from other attorneys nationwide. And that way we make sure that our documents cover everything that needs to be covered and protect their family as best that they can. We have 3 locations, and we can meet with you at any of those locations. We have an office in Aubrey, we have an office in Denton, and we have an office in Bartonville. We would love to meet with you at any of those locations. I have several books, and if you're interested in getting a copy of those books, you can contact our office to get a copy of those books. So we have the Who Gets Your Stuff When You Die, which is our most popular book. We also have Living with Alzheimer's, and I wrote that book because I had 2 different clients whose husbands had Alzheimer's that the wives actually died first. They both died from pneumonia, but I really think they both died from exhaustion. So part of the message of the book is to be sure and take care of yourself if you're taking care of somebody else, because 60% of caregivers die before the person they're taking care of. And then I have two newer books. One is Will Your Spouse Know What to Do If Something Happens to You? The other is Will Your Family Know What to Do If Something Happens to You? Both of these books have very helpful checklists of things or of information that your family would need to know if something happens. Those checklists are also on the website if you're interested in getting those there. So this is not just another living trust seminar. We're going to cover the basics, but we're also going to explain why many living trusts fail. You're going to learn how a living trust should be properly built, maintained, and driven for your loved ones. You're also going to learn about our exclusive trustee manual. So back when I was in my 40s, in case you're curious, I'm in my 50s now, but when I was in my 40s, I had a lady come in. She was in her 90s. She was in really bad health. And I was explaining to her that when she passed away, I was going to walk her children through what to do with her trust. And she looked me in the eye and she said, "Honey, what happens if you die first?" You know, at the end of the football game where the players pour the water over the coach, the ice water over the coach, that's exactly what that felt like to me in that moment. Because in that moment, I started thinking, oh man, what if I don't outlive her? What could have happened that would cause that to happen? Now, I have now been talking about if I die first for over 15 years. And in the event I pass away first, I've written two manuals for my clients. One is a trustee manual. It walks the trustee through what their responsibilities will be. It's actually about a 200-page manual that covers every question that the trustees ask, the instructions that we would give to your trustee in the event something happens to you. So that way that the manual's there. I've also got a beneficiary manual that explains to the people you're leaving money to how the trust protects them. So we're going to talk today about a lot of protections for your beneficiaries. The manual walks them through how to make sure that they take advantage of those benefits. Other answer to if I die first is some of the attorneys in our office are younger than me. I intend for this firm to continue beyond me, but in the very unlikely event it goes away totally, the manuals are there to give instructions to your family and then also to give instructions to the next attorney. So let me talk to you about what a living trust is. It's a legal document similar to a will. They both specify who gets your stuff when you die. The distinction is, does somebody have to go to court? So in the event you have a will, and the will specifies who gets your stuff when you die, and you pass away, the only way that that will is effective to do anything is if you go through a process called probate. Probate in Texas takes about 6 months and costs between $4,000 and $6,000 if everything goes smoothly. So if the will is properly written, it's been written by an attorney and done correctly, then you could actually go through the probate process in about 6 months. If it's not written correctly, then it could cost your family thousands of dollars more than that. And it could also take over a year to go through the court process. And one of the warnings I would give you about online wills is they say that 2 out of every 10 work. In the last few years, we've actually seen the 8 that don't work, and all 8 of them caused their families to spend $15,000 to $20,000 going through the court process trying to clean up the mess that was caused by things not being worded in a way that was clear. So one of the things that we've heard the saying before, you don't know what you don't know. And part of the problem with online wills is when you're answering the questions, you may not know how the language has been interpreted by the court in the past, or you may not be clear enough for a court to interpret the language that you add in. So the will is one choice. There is that court process. One of the misconceptions I hear a lot between married couples is they assume that because the will leaves everything to the surviving spouse, that happens magically if one of them passes away. The magic is actually a court process called probate. So the other choice is to do a trust. A trust is a document that you're in charge of during your lifetime. If you pass away, the people you've named next are in charge. If you become incompetent, the people you name next are in charge. So after signing the trust, a second step occurs. You take your assets and you put them into a trust. You are the initial person in charge. It's revocable, changeable, and you are the beneficiary of the trust. One of the things that we're trying to emphasize a lot more with our clients nowadays is we can draw up the most beautiful trust ever. Has the perfect language in it, covers everything you need. If you don't do the work to get your assets in the name of the trust, it's not going to actually help your family. So we're really starting to give more instructions to our clients about how to get the assets in the trust. We're giving you more reminders to make sure you get your assets in the name of the trust, because we're realizing the importance of that, and we're wanting to make sure that you take those steps. So during your lifetime with a trust, it's business as usual. You stay in control. This type of trust is amendable and revocable. Now, real quick, let me tell you a little bit about just a general overarching of two types of trusts. So trust can either be revocable, changeable, is what revocable means, and that's what we're going to talk about today. The other type of trust that we do is an irrevocable, unchangeable trust, and we're not going to be talking about that today. But the reasons why you would want an irrevocable trust is if you're trying to protect your assets for Medicaid. So if you go to the nursing home, you want to make sure you don't lose everything. Or if you're trying to give assets away for estate tax purposes. Or the third reason why you would use it is if you want to give assets to your kids during your lifetime in a way that it's still not vulnerable if they get divorced or sued or have creditor problems. So I've had some clients who have bought a house for one of their children. They'll buy it in an irrevocable trust, an unchangeable trust, that way, and let the daughter be in charge of it, but make it where then that way if she gets divorced or if she gets sued, she can't lose the house. So why a living trust is better than a will or joint tenancy. You can make sure it gets distributed to the right people, and that's important whether you're married or not. So occasionally I'll talk to somebody and they'll say, well, can I just take all my assets, make sure they all have beneficiaries on them, that way I avoid probate? And the answer to that is yes, but people don't always die in order. So if you were to take your account, name your 3 children as beneficiaries, as long as your 3 children survive you, that works out okay. You could even make your 3 children the beneficiary on your house, but you've got to make sure they get along well enough to be able to agree on how to sell it and what to do with it. Because if you give it to them that way, it can cause problems. One of the advantages to giving it to them through a trust is you can name who's in charge. You can also, with a trust, defer distributions until you think it's appropriate. So you can pick an age that somebody's in charge of their own money. You could also pick a similar age for younger generations. And the living trust may avoid court. So it may avoid the interference, delays, expense, publicity of going to court. Now, you may be thinking at this point when I say it may avoid court, you're like, wait a minute, the whole reason why I'm setting up a trust is I want to avoid court involvement. But if you haven't put your assets in the name of the trust, that's when we're not avoiding that court involvement. Now, there's people out there that actually sell trusts. I call them door-to-door salesmen. They're actually selling you investments. So there are people that will come to your house, they will talk to you about investments, and they will mention to you that they can get a trust prepared by an attorney for you. You never meet with the attorney. That salesperson actually takes the information, sends it to the attorney sends you documents. They're in these beautiful binders. It's a really thick, large trust, so in your mind it looks like it's got all the language it needs. But there's a lot of flaws with it. Part of it is you haven't received any advice regarding your trust. So any of the things that need to be in there to make sure that things work smoothly for your family, they're not going to get put into the plan. Because if you think about it, if this salesperson is gathering a little bit of information from you and the attorney is creating a document, it can't be customized to your family situation. The other downside of these trusts is most of the time they don't get funded, meaning the assets don't get put into the trust. I've seen many of them where what they do is they actually have you attach a schedule, an exhibit that lists all your assets. The downside to that is that's not recognized in Texas. So in the event you have a schedule that lists all your assets, but you don't actually take the time to put them in the name of the trust, then your family is going to have to go through probate to get those assets in the trust. The other thing that happens a lot with these packages is they will tell you that the reason why there's a pour-over will in it And with our packages, we also do a pour over will, but we don't want you to use it. We want it to be a safety net just in case it's needed. But the door-to-door salespeople or the investment people will tell you, oh, when you pass away, your loved ones will probate the will, and that's how they'll get assets in the trust. Well, two of the greatest benefits of having a trust is we're avoiding probate if you pass away, and we're avoiding guardianship if you become incompetent. And by setting it up with either a schedule or a pour over will and not funding it, you're actually not getting those advantages. So one of the hard things with looking at your trust to decide whether it works properly is just because it's really thick and it's in a pretty binder doesn't necessarily mean it's a good document. Now, I can tell you if it's only 10 pages long, it probably doesn't cover everything you need. So we cover a lot of what ifs. So we cover what if one of your beneficiaries becomes disabled and they need government benefits in the future. We actually put in a standby supplemental needs trust. It's a trust that allows that beneficiary to have the money you've left them, but doesn't count against them for government benefits. That takes up about 20 pages of our trust. We also have a very strong no contest clause, because I haven't run into anybody who wants their family to fight when they're gone. The no contest clause says if anybody contests anything, they actually can lose their inheritance. Now, the case law, so courts have said that if we do a really short no contest clause, so if we do it in a short, maybe 3-sentence paragraph, they won't actually assume that you meant this particular contest would make them get disinherited. Our no contest clause is 1.5 pages long because we want to make sure your family doesn't have an incentive to fight. And the living trust may be designed to reduce or eliminate estate taxes. So right now, estate taxes, which are the federal taxes if your estate's over a certain size, the exemption on that's high enough that most of our clients aren't worried about it. It's approximately $14 million. It's very likely that they will continue that exemption. But the question really for estate taxes is what is the exemption when you pass away? So what is the exemption going to be 20 years from now, 30 years from now, whenever you pass away? That's the number that's actually relevant. And when I first started, the exemption was $600,000. It went to $625,000, $650,000, $675,000, and then it started being $1 million. And now it's gone to the really large number of $14 million. Congress talks about reducing it down to a much lower number, talks about it about every year. But so far, they haven't made the adjustment back down. But at some point in your lifetime, they might do it. And especially if they continue to try to reduce the deficit, that's one of the areas that they might look at. So the only time we recommend joint tenancy or beneficiaries on your account as a way to handle your estate is if you're pretty sure that your beneficiaries are going to outlive you. So in a situation where you know you have less than 6 months to live, or you're in a situation where you mainly only have liquid assets, so you don't own any real estate, and you're also older and more likely to pass away in a short period of time, then it would make sense to have your plan be based totally on beneficiaries. But the beneficiary designations on the account don't protect the ones that are receiving the money from divorce creditors and lawsuits, and they don't cover the what if something happens to them, where does it go next? And the big advantage to a living trust is it avoids the probate and the guardianship, the court involvement. So unfortunately, all living trusts aren't the same. I've already kind of mentioned to you situations where you could have a really large trust in a pretty binder and still have it not work. And the hard part is just by looking at it physically, you're not going to know whether it has the right provisions. There was an attorney in this area, he is now retired, but that attorney in his documents actually added language that the only way that anybody could step in on your behalf if you were incompetent is if a judge in his non-judicial capacity certified that you were incompetent. Now, you cannot find a judge that would be willing to do that. So if a judge makes a ruling on the bench in court, he's actually immune from being sued. But if a judge personally declares you to be incompetent, he would be able to be sued for that. So you're not going to find a judge that's willing to do that. And one of the main purposes of a trust is to avoid having to go to court. But the way that attorney wrote those trusts, it's going to require any family member who's trying to declare somebody incompetent, it's going to require them to go to court. And that language is just in the boilerplate towards the back of the trust, and it might not even be caught by somebody reviewing it or checking it on your behalf. So when you're choosing a firm, I would recommend you find one that does estate planning and elder law. So that way you're sure they cover everything that needs to be covered with your family. One of the advantages to finding a firm that also does elder law is that firm is actually going to be able to go with you through life. With our clients, we meet with you every 3 years, and part of that is so we can walk alongside you in life. Because at the time we created your plan, you may have been perfectly healthy, had no thought that you or your spouse are going to end up in a nursing home. But as we progress or as time goes on, one of you might get diagnosed with Alzheimer's or dementia, and we'll need to adjust your plan for that. And because we do elder law, we're going to be able to spot issues related to protecting your assets if you ever need care. Attorneys that only do estate planning aren't going to know to even look for those issues. So in saying that all living trusts aren't the same, think about it. Are all cars the same? Is the only difference the price? And even if they were the same, are they built and maintained the same? Now on this slide, I have a wrecked Yugo. And a Yugo is a car that actually Consumer Reports said it was the most dangerous car ever built. A more modern car that some of you might be aware of that would fit in the same category would be the Ford Pinto during the period of time that the gas tanks would explode if it was hit at a certain angle. And the problem is, when are you going to know what you've actually got with your living trust? Because if you think about it, with your living trust, it's important to you that it works when it's needed. So in the event you pass away or become incompetent, is it going to work properly? And really, the time you're going to know whether it works properly is when it's actually needed. And at that point, it's usually too late to make adjustments. So you might be thinking, what could go wrong with the trust? And I'm going to walk you through some things that can go wrong. Will it work properly if you're ill or disabled? And I said at the bottom of this slide, you don't think this will happen to you. Because if you think about it, when we're having a conversation, it's hard enough for you to think about, if you die, where do you want your stuff to go? But a harder question is, what if you're incompetent? What if you're unable to take care of yourself? Who do you trust to step in? And if you have any dysfunctional family members, we need to actually draw up documents that disqualify them from making decisions. Because I can tell you more stories than I'd like to of people that don't even have a relationship with mom and dad trying to step in and trying to be in charge when mom or dad become incompetent. So if we have people you wouldn't trust to take care of you, we need to list those specifically and disqualify them. And then we also need to specify who you trust to be in charge. And one of the advantages to having a trust in place is it makes it where the court will follow who you've named to be in charge, and they will not appoint the people that you've disqualified. So another thing to watch out for in documents is whether they cover HIPAA. So HIPAA stands for Health Insurance Portability and Accountability Act. It was passed in 2001. The purpose was to keep doctors and hospitals from selling medical information. But there are a lot of things that causes to happen within trust that a lot of attorneys still haven't caught on to. So even though it was passed 2001, so a long time ago, the HIPAA law actually says that if doctors or hospitals release your medical information without permission, they can go to jail or pay huge fines. The problem with the law is it doesn't have a standard form. So there's not a standard release that you can sign that every doctor and hospital will accept. When the law first came out, every doctor and hospital hired an attorney to draft a privacy authorization, and they were told that if you sign their authorization that they can't get sued. So every doctor and hospital is going to want their specific form signed in order to release information. So what we do for our clients is we provide a HIPAA release that lists the people you want to have be able to check on you in the hospital, talk to the doctors, look at medical records. We also add language to your financial power of attorney and your medical power of attorney that those people can sign whatever the doctor wants signed. But the part that most attorneys have not caught on to that needs to be incorporated in documents is a privacy release for whoever takes over your trust. So in the event you're alive but you become incompetent, or actually even after you pass away, whoever takes over as trustee, our documents say that when they take over, they've got to give the next in line a privacy release. I told you at the beginning, we belong to professional organizations and we can learn from the other attorneys in the professional organizations. One of the lessons that we learned from another attorney is they had a situation where a client was incompetent. Their son had taken over as trustee of the trust. The son started acting erratically, and the daughter noticed that he was acting erratically and wanted to find out from doctors what was going on, but she didn't have the right to look at his medical records. So she ended up having to go to court, getting a court order to get the right to look at his medical records to find out what was going on. Now, the good news is that he hadn't done anything wrong with mom's money. The bad news was he really was having trouble. He ended up in a mental hospital for a period of time, and then he was able to get medication and get better. And what we learned from that is that in our documents, we actually add, when you have somebody step in on your behalf, we add language that says that they've got to give access to medical records to the next in line. So if the next in line needs to step in, they know enough information to know what's going on. Because otherwise, they're going to have to get a court order to have access to it. During that delay, the person that's in charge of your assets might actually make some bad decisions regarding your money. So other question on whether your trust will work properly if you're ill or disabled is, can your chosen person step in immediately or do they need to go to court? Now, I've already told you about the language that said a judge in his non-judicial capacity had to certify that somebody was incompetent. That would require somebody going to court to get you declared incompetent in order to step in. I've also seen trusts that attorneys put in the language that the only way your next trustee can step in is if a court declares you to be incompetent, which I see as defeating one of the purposes of the trust. One of the purposes of the trust is to make it where nobody has to go to court under any circumstances. So our documents actually say, in the event 2 doctors certify you're incompetent, then your next trustee can step in. So that way they can step in easily if they need to. Or I talked to you about HIPAA and how HIPAA can make a difference in whether somebody can step in. They've got to have access to your medical records in order to get 2 doctors to certify that you're incompetent. They've also got to have access to the person in front of them if it needs to be a successor trustee. So the next question is, can you easily come back in if you get well? So this is also a lesson we learned from another attorney that's in the professional organizations that we belong to. They had a situation where there was a lady who was in a car wreck. She ended up in a coma. She was in the hospital for a period of time. Her son took over as trustee. And then when she got out of the hospital, she went to her son and said, "Thank you for taking good care of my trust. I appreciate you taking care of my assets and things while I was in the hospital. Now that I'm better, I would like to step back in." And her son's response was, "I really like being in charge. I'm a little concerned that if I let you be in charge again, you're going to give a good portion of the assets to my sister." And so this poor lady actually had to fight in court over control of her own trust with her son. Now, in the end, she did regain control of it, but our documents actually say, in the event you get better, because sometimes the inability to manage your finances is temporary. So in the event you get better, you have the ability to step back in and to regain control. So next question is, will your trust really avoid guardianship and probate? So powers of attorney. So prior to 2018, nobody in the state of Texas was required to accept a power of attorney. The state legislature decided that that was inconvenient, and it is. So they came up with a standard form. And in the statute, they said that in the event you have this statutory standard form power of attorney, that people are required to accept it. And then they put it out for comment. And when they put it out for comment to the attorneys and different people that they asked, people came up with a whole lot of scenarios where that's a bad idea. So one of which I can give you that we would all agree to is, what if it's a forgery? What if you were incompetent when you signed it? I mean, there's a whole lot of things you can think of that would be exceptions. So I always explain it to people that the law actually says that the statutory power of attorney is mandatory to take with 16 exceptions. And most things can fit within those 16 exceptions. So if you were to have a will-based plan and you're relying on your power of attorney as the ability of people to step in if they need to, it may not work when it's actually needed. The other problem with power of attorneys is that you can revoke them. So let me give you an example. Years ago, I was actually hired by the court to represent a man whose son was trying to get guardianship over him. This man believed that he had won $115 million in the Jamaican lottery. By the time his son figured out that he was being scammed, he had actually sent over $200,000 to the people scamming him. Because his father actually had a back injury, had a pain pump, and he had some short-term memory problems. And so he really didn't remember that he had sent $200 over 1,000 times. So when his son showed him that he had actually sent this $200,000 to these scammers, the dad's response was, they just need $500 more, and then they're going to actually get me my money. And then the son said, okay, well, I'm going to take care of dad's finances or take over dad's finances under his power of attorney. So the dad revokes the power of attorney. So at the point where the dad revoked the power of attorney, there's no court ruling that he's incompetent. So the dad can still revoke the power of attorney. So dad revokes the power of attorney. So son's only choice as far as getting in control of dad's finances at that point is to go through a guardianship proceeding. That's a court proceeding where the court determines whether you need someone to help you with your finances. And the bias of the court is to not take away people's rights. So you try not to take away rights unless it's absolutely needed. So my role with the court was to defend him against this guardianship even if I thought he needed it. So my job is to put up as much defense as possible against it if the father wants to fight against it, which he did. Now in the end, the court did rule that he needed a guardian. And the other part of the story that I didn't tell you yet, which is very important, is that my clients who have been scammed have actually been some of the smarter people. So this particular man, prior to being scammed, his job prior to retiring was to negotiate multi-million-dollar international contracts. So part of why the scammers were able to get to him, where they were able to actually convince him he was negotiating another multi-million-dollar international contract, which made him feel useful. And he also was used to having to bribe governments in order to get money. And so that's part of what they played into and how they did this. So this man who's very smart, but starting to lose his ability to make good decisions, the court did rule that the son should manage his finances for him. The sad part is this poor man had to watch his whole family and friends testify that he was making bad decisions. They actually had to call the sheriff's office and put him on suicide watch because they were concerned that he might commit suicide because he was so depressed that his family had turned against him. So without a trust, you have a risk that in the event you become incompetent, it becomes this embattled court thing as compared to just having your loved ones be able to get doctor's letters and be able to step in when they need to. So another reason why your living trust might not avoid that guardianship proceeding that I just described or probate is if you haven't gotten all your assets in the name of the trust. So that's one of the things we're emphasizing more with our clients. We've always emphasized it, but we're trying to make sure that they get it done because we've had a few of our clients pass away. And of those clients who pass away, about 10% of them have not put all their assets in the trust. So that 10%, the family's still having to go to court. And the common question we're getting related to that from those families is, wait a minute, my parents spent all this money setting up a trust so that so we wouldn't have to go to court. Why are we having to go to court? And the answer is it's because the parents didn't actually get the assets in the trust. So we're giving more and more instruction on that, more and more follow-up, because we're trying to make extra sure your trust works when it's needed. And the other important thing is to think about later acquired assets. So we meet with our clients every 3 years to check in and see how life's going. One of the most common things for people to say to me when they come into that meeting is, right before coming in, we realized this asset was not in the name of the trust, and we went and got that asset in the name of the trust. Or they will ask me how to get that asset in the name of the trust. So that's one of the advantages to us meeting on a regular basis, is making sure, is another check to make sure you've put everything in your trust. I've already talked to you a little bit about why a pour-over will is not enough. Now we do one because we've had situations where people don't put things in the trust, so that 10% that requires probate, we need a will in order to probate. But my goal is for you to have everything in the trust, so that way your family doesn't have to go to court if something happens. But the pour-over will is there as a safety net just in case. The other thing that won't work, which I told you about the door-to-door salesman on trusts, they'll tell you just to put everything on a schedule. As far as I know, the only state that works in is the state of California. So the state of California actually has a statute that says that anything you list on a schedule is automatically owned by the trust. As far as I know, that's the only state in the United States that works on. In Texas, you've got to get your assets titled in the name of the trust to avoid probate and to avoid guardianship. So the other important thing to bring up here is, if you've moved here from another state, that's one of the reasons why you want to have your trust looked at, to make sure it works under Texas law. And especially if it's a California trust, we're going to talk about making sure all your assets are in the name of the trust. The other thing to look at if you've moved from out of state is your will probably need to be updated. Because I mentioned earlier, there's two types of probate. There's the one that takes about 6 months, costs between $4,000 and $6,000. The other one that takes over a year and can cost $15,000 to $20,000. If your will doesn't have the right language for Texas, you're signing up for the more expensive process. So the year-long $15,000 to $20,000. And it's not that your will was done incorrectly in the state it was done in, it's just the rules are different in each state. So if it doesn't have the right language and you've moved to Texas, you're signing up for the more expensive probate, and it's a relatively easy thing for us to fix for you. So will your living trust properly protect your loved ones from losing their inheritance to third parties or the federal government? A big pile of cash for your beneficiaries may be wrong if they're too young, if they're elderly, ill, or disabled, or have drug or alcohol problems, if they're not good at handling money or have immediate creditor problems, or if they're receiving needs-based government benefits. So if they're receiving needs-based government benefits, those benefits require that they have less than $2,000 in their name. There's a few exempt assets they can have with that. So if you were to set up a college savings plan for one of your grandchildren while they're little, and you put $10,000 in that college savings plan, and later it's discovered that they have a disability and they qualify for SSI when they turn 18, that $10,000 will actually make it where they can't get on SSI until that money is spent. Now there's some ways to work around that. I have another video that specifically talks about dealing with beneficiaries with a disability, but it's important to make sure that we don't mess up those benefits for those beneficiaries. Now I'm going to talk to you about ways we can work around that in just a second. But one of the other questions is, will your trust adapt if something changes? Because if you think about it, when we actually set up your plan, we're looking at your family in a snapshot in time. So we're looking at it how it is now. But the question is, when the document's actually needed for these beneficiaries, will any of these things apply, and should there be any protections related to it? One of the things that we do in our documents that is somewhat unique is we have a role called a trust protector. The trust protector's role is the ability to amend the documents to adjust to situations. And the way it works is the person you've put in charge, which is called a trustee, has the ability to appoint somebody to make these changes. And because we have the language in the documents, these changes and adjustments can be made without any court involvement. If the language wasn't in there, then what would happen if your document needs to be changed after you're gone or after you become incompetent, then a court would have to be involved in making those adjustments. So even if you have a really responsible beneficiaries, so none of the things that I listed as reasons why we would want protection are involved, outright distributions may still be wrong. Because if you give it to them outright and the beneficiary gets divorced, that money could be vulnerable to that divorce. If that beneficiary ends up having to file for bankruptcy or has creditor problems, that money will be vulnerable to being taken. And if your beneficiary gets sued, now on this slide I put valid or bogus. One of the easiest ways to settle a lawsuit is to show there's not any assets they can get to. And there are people out there that will file a lawsuit just to get you to settle or give them some money. So if your beneficiary owns the assets that you're leaving to them inside of a trust, in the way we're going to talk about in a minute, then the people suing them won't be able to get to those assets. It also protects against the government forcing that the money be spent or paid over to them if your beneficiary needs government benefits. And even if none of these apply, it also protects against a second estate tax. So I told you earlier, the estate tax exemption is high enough that nobody's worried about it anymore. So it's about 14 million right now. It's getting ready to go up a little bit. But really, the estate tax exemption for the second estate tax, we're talking about in your kids' lifetimes. So I can almost guarantee during our lifetimes, they're eventually going to bring the estate tax exemption down. I can almost 100% guarantee in our kids' lifetimes, they're going to need to bring the exemption down in order to be able to balance the budget. So one of the things we can add language that says that if or when the money you've left to your kids goes to your grandkids, that there's not a tax on the transfer from your kids to your grandkids. And we'll talk about that a little bit more in a minute. So we don't recommend outright distributions, even if your beneficiary is capable of managing their own money, because we can protect it if they were to get divorced or sued or have creditor problems. So what we recommend, we call it a heritage trust. It's a trust where the beneficiary can manage and control their part of the trust. But under the terms of the trust, they don't own it. They are a trustee of it, meaning they're in control of it, but there's certain rules they have to follow in order to get the money. And so because of that, it's protected if they get divorced or sued or have creditor problems. And they can have even greater asset protection if it's needed in the future. That's one of the things that I explain in my beneficiary manual to your beneficiaries. There's some ways that they can have somebody, a friend, step in and help them put even greater protections on the money if it's needed in the future. So I'm going to walk you through a case study. These are our clients, Bob and Betty. They have 3 children. So they have a couple ways that they could leave money to those 3 kids. So the initial one I'm going to talk to you about is if we don't do any protection against the divorce creditors and lawsuits. So we're really looking at it as what happens if we give the money outright to these 3 children. Their oldest child is Bob Jr. He has a high maintenance wife, and they're a little concerned that if they give the money to him outright, that she's going to influence him to spend it. He's also in a profession where he's likely to get sued. He's a surgeon, and they're a little worried that if he gets sued that he might lose what they've given him. And also, if Bob Jr. ends up being successful, and when he passes money down from him to his children, Bob and Mary are concerned that his children would have to pay an estate tax when he passes away on the money that they've left to Bob. Their middle child is Jane. She has a problem marriage. And actually, to be honest with you, Jane doesn't have a problem with her marriage. Her parents just really don't like her husband. And their concern is if they leave it to Jane outright, she's very likely to leave it to her husband. And if her husband remarries, he's likely to leave it to whoever he marries next. 83% of men who lose a spouse remarry, and most people in their estate plan leave all their money to whoever they're currently married to, which means if Jane passes away and she leaves it to her husband Dennis, Dennis is likely to leave it to his new wife, which means Jane and Dennis's kids will not end up with the money. She also lacks the financial experience to manage the money. Now, as we talked that over a little bit more, and I'll talk to you about this a little bit more in the next slide, we talked about some ways that we can protect against that. She's not bad with money. She's just influenced to spend it by Dennis, and they're a little worried about whether she'll know how to manage the amount of money that they're leaving behind. Now, their youngest child is Joe. And really, I ought to almost give this family 4 children, because that way we could kind of talk about Joe in 2 different lights. So Joe either is extremely irresponsible and bad with money, or he could be a person who has a disability that needs a protection. But either way, it makes sense to protect him against himself. Now, the conversation that I have with most parents is if they do a certain structure for Bob, they want to do the exact same structure for the other kids. But if you think about it with Joe, you've probably treated him differently during his lifetime, and there's a reason why you're going to want to give him a little more protection. And if you were to give him the money outright, and it's later discovered that he has a disability and he qualifies for government benefits, he could lose those benefits if you leave him more than the $2,000. So what we recommend for all 3 of them is what we call a heritage trust. Heritage trust is designed for all 3 of them to protect the money if they were to get divorced, sued, or have creditor problems. So for Bob Jr., we could have Bob Jr. be in charge of his part. We could protect it from his wife if they get divorced. We could make sure there's not a second estate tax when it goes down to the grandkids. And we could protect it if he ever gets sued. Now for Jane, when we talked about it, as I said, she's decent with money, but she's influenced by other people to spend it. And she really doesn't know how to invest the level of money that she's going to inherit. So what we did with Jane is we actually added language that said that Jane, once she inherits, has to use the same financial advisor as her parents for a period of time so she can learn how to manage the money. They're confident that she can stand up to her husband and do the right thing with the money, so they're actually going to allow her to be in charge of her own trust. But it'll protect it if she gets divorced, and it will make it clear that if she passes away, it does not go to her husband. All right, now we get to Joe's trust. As I said earlier, parents want to be fair to their kids. So we put Bob in charge of his money. We put Jane in charge of her money. The tendency would be then to put Joe in charge of his money. But if you think about it, you probably have been protecting Joe for most of his life. So in the event you give him the money outright, you let him be in charge, he's probably going to blow it within a short period of time, and then what is he going to live on? So it would be much better for Joe that you put somebody else in charge, so it's protected if he ever gets sued, he's protected from giving it away, and it also makes it where he would qualify for government benefits if he ever becomes disabled. Now, I talked to you about promoting family harmony at the beginning of this. The other tendency of my clients with a situation like this is to put Bob in charge of Joe's money. But really, how do you think that's going to work? So if Joe is constantly asking Bob for money and Bob is constantly telling him no, what is that going to do to their relationship? And how important is it to you that they get along? So most people I talk to, or most parents I talk to, want to make sure that their kids get along. That's one of their primary focuses. So think through, would it work to have Bob in charge of Joe's money? And it might. In some families it does. We've also set it up sometimes where Joe gets a set allowance. So he isn't asking Bob for money on a regular basis because there's a set amount of money he's receiving as time goes on. So we recommend this heritage trust on every trust we build, because we can take it for your responsible beneficiaries. They can be in charge. They can have as much access to the money as they would have otherwise. Most of my clients want it to go to the grandkids. So they want, when their kids pass away, they want it to go to the grandkids next. I have a few clients that may want to include the daughter or son-in-law, but we can do that in a way that it takes care of the daughter or son-in-law and then loops back or goes back to going to the grandchildren. I have a few clients that are okay with their kids giving it to anybody they want to. And if that's the case, we can add in language that does that, but still protect them if they get divorced or sued or have creditor problems. We can always customize your documents to what you want them to say. So what about your potentially largest asset, your retirement plans? Your retirement plans are most likely the largest asset you're going to leave behind. And part of that is because most of my clients who are taking required minimum distributions are complaining about having to pay income tax on that. Now, real quick, let me tell you a little hint with that. In the event you're taking required minimum distributions and you regularly give to a charity, it's actually better to have those distributions go directly to that charity. It actually saves you in taxes on your Social Security. So if you have a situation like that, talk to your financial advisor about having those distributions go directly to the charity. But because my clients don't want to pay any more in taxes than they have to, frequently they're not going to withdraw more out of their retirement accounts than is required by the federal government. And so because of that, that asset is going to grow to be one of the largest assets during their lifetime. And it's left unprotected by your living trust. So with retirement plans, you have basically 3 choices. Now, before I go through this, on our website, I have an entire video on retirement plan trusts that talk through how to protect retirement plans for your beneficiaries. And I would recommend, if you have large retirement plans, that you watch that video. But just an overview for you guys so you have a general idea of what to do with your retirement plans. You have basically 3 choices. You can either name people individually, and they might stretch it out as far as they can under the law, but they're not going to have the protection on that money if they get divorced or sued or have creditor problems. You could name your living trust as the beneficiary, and if it's designed to have that protection language in it, then the money would be protected. But it's not going to get stretched out as far as it can as far as payments over time. Now, in the Retirement Plan Trust Seminar, I go into a lot of detail regarding the Secure Act. The Secure Act talks about taxation of retirement plans, and one of the changes the Secure Act made in 2020 is it made it where most beneficiaries have to take the money out over a 10-year period. But if you were to name a living trust as the beneficiary, or if you were to put on there my estate, or if you don't have a beneficiary at all, it ends up being a 5-year payout, which means the money is taxed faster and probably at a higher rate because more money comes out per year. What I would recommend for your retirement plans is a retirement plan trust. We can add language that allows the maximum stretch out allowed under the law and also has the protection against the divorce creditors and lawsuits. If you have a beneficiary with a disability, and for retirement plans, specifically under the Secure Act, this is, does the beneficiary have a disability at the time they inherit? And if they have a disability at the time they inherit, they're allowed to take the money out over their lifetime. But that's only if your documents are prepared properly. We need to do a separate, secure, supplemental needs trust for that beneficiary in order for them to take advantage of being able to take the money slowly out over their lifetime. If you name that beneficiary directly or an improperly drafted retirement plan trust, it's going to be a 10-year payout. So we've got to be very careful in how that's put together. So you can really think about the retirement plan trust as a living trust for your retirement plans. You should consider it if you or your spouse have IRAs or other retirement plans over $200,000, or you have a beneficiary with a disability, or you have a beneficiary who's irresponsible with money that you want to protect them against themselves. The other reason why some of my clients will do a retirement plan trust is to make sure that their spouse leaves the money to the people that they've agreed upon. Now, throughout this speech, I've been talking about people with kids, but everything I've talked about would also apply if you're leaving money to your nieces and nephews or to your best friends or whoever you're leaving it to if you want to have it be protected. So there really is a lot more to proper estate planning than just filling in blanks on a form. So do your documents reflect proper counseling? So one of the downsides to preparing your own documents online is that you're not actually getting the advice on how to fill them out. So a fill-in-the-blank form may not cover what needs to happen. Similar to the ones I told you that were created by the door-to-door salesman, those are fill-in-the-blank forms that don't necessarily cover all the circumstances that they need to cover. So some of the common issues that you might encounter when you're trying to design your own plan is how to choose your trustee. So how to choose who's in charge. I already kind of gave you the advice of whether it's a good idea to have one child in charge of another child's money. But part of what you're going to want to talk through with an attorney is how to make that decision. You may also want to talk through who to have a successor beneficiary. So I told you it's already hard enough for us to think about if we die someday, who do we want to have receive things? Harder question is the people we care about, what if they're gone? Where does it go next? Who do you want to have get it in the event something happens to your whole family? And we might talk about having a professional trustee. So a bank or an investment firm be your trustee if you're gone, so that way it promotes family harmony among your kids. Especially if there's a certain amount of conflict already, it might be a way to make it where things go smoother after you're gone and they can preserve their relationship. Other thing to talk through is how each beneficiary should receive their benefits. So similar to what we talked about is how do we structure the trust for Bob, how do we structure the trust for Jane, and how do we structure the trust for Joe. And because each family member is different, we're going to customize it differently to each of their individual situations. So the question is, do you get this level of professional advice when you do a do-it-yourself online will, or if you work with a bargain attorney? Because sometimes what people think is they know they need a trust, so they just call around and they find the cheapest possible attorney to put it together. And it may be an attorney that mainly does personal injury or divorces, and they don't really know a whole lot about estate planning, so the quality of their documents is not going to be quite the same. So special issues for singles. So if you're single, you really need to think through who's going to handle medical and financial decisions for you if you become disabled. And if you live with somebody, you need to think through what do you want to have happen with the house. Do you want that person to continue to be able to live there for a period of time and then the house be sold? Do you want them to be able to live there for life and have them pay certain expenses? So if you're living with someone, we need to talk through that. Also, if you have a partner and you want your partner to be able to check on you in the hospital, talk to the doctors about what's going on medically, we need to add them to the privacy release. If you want them to make medical decisions, we need to add them to your medical decisions. So people that you're living with don't automatically have rights to information or to make decisions unless you've got documents in place to allow them to do that. So that's one of the things to talk through if you're not married. So which car would you want your loved ones to drive? The wrecked Yugo or a brand new BMW? And are you willing to gamble away your loved one's future on what you actually have? Because like I said, a trust could be in a pretty binder, be really thick, look really pretty, but it might not actually cover everything you need it to cover. So where do you go from here? Most people end up procrastinating. But it's actually easier to put together a plan when there's not a crisis going on. Now, we put together plans for people all the time that are going through crisis. But it's a much easier conversation if it's a, if I die someday, how do I want things to be put together, as compared to, I think I'm going to die in the next month and we have to talk through it. So the earlier you plan, the more control you can maintain, the better plan that you can put together, and then that way that plan can grow with you over life. And we're going to meet with you every 3 years and just check in and see how things are going, so we make sure we keep the plan up to date. We would love to meet with you to get to know your family and to help you design a plan that works for your individual family situation.